hearing of the evening. This is the 7:15 hearing, and it's on the application of Richard and Kimberly Golden. I'll briefly describe the application rather than reading it. The Goldens own property at 11 Antwerp Street in Milton, and it's located in a residential C district. Mr. Golden has a detached garage to the right rear of his existing residence, and he was proposing to build an addition onto the garage that would be 7 foot 9 inches by 20 feet 4 inches. And it would be a one-story addition. The end result of the proposed project would be that the addition would be set back 6 inches from the right side property line rather than the 8 feet required under the bylaw. We held hearings on this particular application on October 15, 2013, December 18, 2013, December 10, 2013, and we're here again tonight. Let me cover some of the just preliminaries. We had to.
May I sit down?
Oh, of course, Mr. Golden, come on up.
Thank you very much. Your first name again?
My name is John.
John, nice to see you again.
Thank you. Let me just cover a couple
Yep,
of
go right ahead.
preliminaries, just for the record.
Sure.
My name is John Leonard. I'm chairman of the Board of Appeals. With me this evening, to my immediate left is board member Virginia Donahue King.
I know Virginia loves me.
Well, Virginia loves everybody, Mr. Golden,
Ooh, don't let that get around.
including Mary.
At least this time she could speak. Last time she had the laryngitis. She had been away on a trip.
She
and
did.
She was able to speak.
And she's
That was the
recovered.
best meeting I had. No disrespect, but that was the best meeting I had at Virginia.
Thank you.
Go ahead, go
We'll
ahead.
take note of that,
Yep,
Mr.
thank you.
Golden. We know it's made in good faith. To my immediate right is board member Ted Daber.
Sure.
The rules of the board for this hearing is we'll hear from Mr. Golden, we'll hear from anybody who wants to be heard on the application. We're tape recording the hearing this evening, so would ask that before anyone speaks, tell us your name and address, speak up nice and clear and loud, so that we'll have an accurate record of the proceeding if we have to revert to that for the purposes of preparing a decision. So with all of that as a folderol, Mr. Golden, it's good to see you again. Welcome back to the
Nice to
Board
see you,
of Appeals.
folks. This is the last time we're going to meet. Thank you very much.
Okay, why don't you tell us what you
Richard
have
J.
in
Golden,
mind?
11 Antwerp Street, Milton, Massachusetts, 02186.
Good. Why don't you tell us where your application
I would respectfully like to withdraw my appeal. It's not going to work out, and it is what it is, and I understand I didn't go about it the right way. And so respectfully, like I said, I'd like to revoke my appeal, and I'll deal with it. I've got it. I know what I can do now, what I cannot do.
Okay, so, and I assume, Mr. Golden, what you want to do is you want to withdraw your appeal without prejudice, so that you can come back without waiting a 2-year time
Without
period.
any prejudice, yes. I'm giving this whole thing up. I'm swallowing a lot of money, but here nor there. It was my fault. I went about it the wrong way, and, yeah, without zero prejudice, no prejudice whatsoever.
Okay, and I mean without prejudice to you, so if you changed your mind or
Oh, no.
decided to-
John, with all due respect, I made a mistake. You did not. I did.
Okay.
I'm a big boy.
Well, we appreciate your candor, and we appreciate the good faith that you've shown throughout this rather lengthy process. I know it's been an ordeal for you and your family, and it just hasn't been easy.
John, may I ask one favor, please? If you folks, Virginia and Ted, right?
Sure, what
If
do
would,
you have in
please,
mind?
is, can you just give me a little time to take it down? I'm not asking for a ton of time. It's winterized, it's not in like an eyesore on the neighborhood or what have you. I mean, the one gentleman who wrote a letter against me, he lives like here, and I live like there. He can't even see it. That being said, it is what it is, and that's fine with that. But can you just give me a few weeks to take that? I don't want to be unscrewing.
Sure, would
Would
30
that's
days
all
give
I'm
you
asking.
enough time?
What I would ask for, if you don't mind, John, if you don't mind, is before Memorial Day weekend, which would be about 45 days, sir.
Okay. All right, well, let's.
Is that reasonable? See, now,
I'm
I
gonna
talked
ask-
to, I'm sorry, go
I'm going to
ahead.
ask my colleagues whether they think that's reasonable. Mrs. King, do you want to be heard on Mr. Golden's request for
appears-
45 days?
It appears reasonable to me.
Okay, Mr. Deba?
I agree. I mean, given the kind of weather we've had and that we may have, I
Thank you,
think the
Ted.
additional-
Exactly.
Okay, let me just see, Mr. Golden, if there's anybody out there who wants to be heard first on Mr. Golden's request to withdraw his application without prejudice to coming back at some other future time. And it appears that nobody is out there who wants to be heard. Is there anyone who wants to be heard on the issue of giving Mr. Golden 45 days to remove the existing structure so that the garage will be in conformity with the bylaw? Okay, and the record indicates there's no such person present, so if you have nothing further to add,
I do
you
actually.
do, okay.
And I'm sorry.
I should tell you,
I try to-
you're
I'm
ahead
not
now,
trying
so you
to
gotta be
better than
very
I-
careful. Go ahead. What else do you?
May I ask you one question? And I know it's not up to you, and believe me, I know that. Why, Milton's kind of tight. I don't live on the rich side of town. I live on the East Milton side. And I'm not saying one is rich and one's not rich. I don't care about money, what have you. I have. But why in Needham and Mansfield can they develop 2 feet inside their property line? And I wasn't inside the 2 feet. I was wrong. I was not even inside the 2 feet. But why is Milton 8 feet when we're dealing with such smaller lots, like there's such small land? Who sets those rules or those governing? That's my question.
Sure. That particular rule is a long-standing rule
But it's not right.
to the best of my knowledge, Mr. Golden. And what it's established by the Milton Town Meeting, which is again coming up. And so you have the perfect opportunity, not for this town meeting, but maybe
Sure.
next year, because I think all of the articles
Have already
and warrants
written,
have been
yeah.
submitted, and they have to be approved by various boards. But you have the perfect right to bring what you believe to be an unfairness to the attention of the selectmen or the planning board, or you could file a citizen's petition, I believe, in order to make the bylaw dealing with side setback distances more flexible.
Sure.
Or, to give the board more flexibility. But this particular application, as you know, was,
I'm wrong all day long.
well, it's not a question of being
wrong.
wrong.
No, I'm wrong.
You did your very best, but it was an extreme application, and at 6 inches off the property line, so the board didn't look too favorably on that.
Sure.
But I think that's what you should be doing. If you really want to change that part of the bylaw, you can certainly talk with Mr. Prondak or,
Yeah, Joe, yep.
yeah, Joe, and talk perhaps to the planning board, or find out from the selectman's office. I think you may need 10 citizens to do a citizen's petition.
I don't have 10 friends, John. How am I gonna get?
Well, I bet you have a lot of friends, and
I don't think that.
and then you could make that presentation before town meeting, and
Milton is so set in their ways and what have you. And somehow we gotta get to realize that it's 2014 now. It's not 1994. That was 20 years ago. I mean, if Needham and Mansfield have so much more room than we have, and we have close things, I'm not saying 8 feet should become 2 feet, but can we agree on 4?
well, look at, you make a very reasonable suggestion in the sense that Milton's an old town, and there's certain
Sure it is.
sections of Milton that have these 4,000 and 5,000 square foot lots, and if you needed an additional bathroom, or you need any significant improvement or modernization of the house, more often than not, you have to come before the Board of Appeals and go through the expense of the variance process. And there are greater minds out there than ours. We enforce the bylaw, but we don't write it. The planning board gets involved in submitting a lot of warrants and amendments to the zoning bylaw, and Mr. Whiteside, Alexander Whiteside, is the chairman of the planning board, and has been for many, many years, so you certainly have the full opportunity to talk with him. I'm sure he'd be delighted to meet and talk
He's
with
a
you.
he's a very nice man.
And he could perhaps explain certain alternatives that may better address this situation.
I understand.
So with all of that having been said, all those in favor of granting Mr. Golden's application to withdraw his application without prejudice and to specifically give Mr. Golden 45 days from the date of the entry of the withdrawal, which will probably be 2 or 3 days from now, to remove the offending structure, please say aye.
All right.
Thank you for,
I thank you for,
Thanks for
Virginia,
stopping
thank you.
by, Mr.
John,
Golden.
thank you. Ted, thank you very much. Mary, thank you.
nice to see you.
Good luck.
Nice to see you folks. Thank you very much.
And we'll send you a copy of the withdrawal, so you'll have it for your records, Mr.
Please,
Golden.
thank you. Mary, thank you very much. Have a nice evening, folks.
All right, shoot. Want me to do it?
Well, you just have to do a withdrawal.
Well, do we have to put the,
In the 45 days
yeah, and then you said from the entry of the,
from the entry of the withdrawal. Yeah, do you want to try, do you want to do it? Mary can do it, I think.
okay.
Do you want to try, Nancy?
Yeah,
That's-
I'll do it.
And just send it around for 3 seconds. Thank you.
Musical chairs.
Oh, I'm sorry. Thanks, Teddy. We appreciate it.
All right.
Have a good night.
Thanks, you too, Mary.
Thank you for coming.
Hey, Brian, how are you? Nice to see you. How have you been?
I've been good.
Let me know when you're ready.
I'm all set.
How's it, Barry? Okay. Ladies and gentlemen, we're going to call to order our second hearing of the evening. It's a 7:30 hearing, and this is on the application of Michelle and Abram Cardoza. Let me summarize the application rather than read all the technical parts of it. The Cardozas have an application dated March 6, 2014, and they seek a variance from the terms of Section 6C1 of the Milton zoning bylaw so as to build a 12-foot by 5-foot 5-inch, one-story addition to the rear of their existing residence. They presently live at 115 Pleasant Street, Milton, Massachusetts, which is located in a residential C district. The proposed addition is supposed to be set back 7 feet from the right property line rather than the 10 feet that's required by Section 6C1. My name is John Leonard. I'll be acting as chairman for this particular application. With me this evening to my immediate right is Board Member Theodore Daber, and to my immediate left is Board Member Virginia Donahue King.
Poor Brian Hurley.
Oh, I'm sorry, excuse me, we've had a switch. He doesn't look like Theodore Daber to me. This is Board Member, the distinguished Board Member, long-standing Board Member Brian Hurley. Thank you very much, Brian. The rules of the board are such that first we'll hear from the applicant, and then we'll hear from any people who have questions of the applicant. We'll hear from people who wish to speak in support of the application, and any people who wish to speak in opposition to the application. We're recording the proceedings this evening, so that we'd ask that before anyone speaks, tell us your name and address. It's a fairly large hall we're in tonight, so speak up nice and clear and loud, so we'll have an accurate record of the proceeding. In addition to the advertisement, which I've just summarized, we'll have as evidence at this particular application the Cardoza's application, which is dated March 6, 2014. We have a February 28, 2014 denial letter by our building commissioner, Joseph Prondak. We have a plot plan of land by Robert E. Hannigan and Associates. It's dated February 26, 2014, and it's entitled Plot Plan 115 Pleasant Street, Milton, and it shows the existing dwelling and the proposed two additions to the structure. We also have some construction plans. They're not sealed or signed, but they're by Randazzo Dwyer Architects. And we don't know where they're from, but maybe it's on some other sheet here. Sheets A1, A2, A1 being the site plan, A2 being the proposed floor plan, A5 being an elevation plan, and A6 being a proposed exterior elevation plan. So we thank the applicant for submitting these particular plans. So with all of that as a rather long preamble, welcome to the Board of Appeals.
Thank you.
We're delighted to hear from you in support of your application.
Thank you. My name is Abram Cardoza. My address is 115 Pleasant Street, Milton. And before I start, I want to thank the board for taking under consideration our request for variance this evening. As you stated, my wife and I are proposing, it's actually two small additions, but only one of them was denied, and which we're seeking a variance.
And that's on the right side lot line.
Yes.
Yes.
Yeah, and I actually have some supporting images. I don't know if I can.
Sure, come on, bring them up. We're delighted to have them. Are those copies we can keep
Yes.
as part of our decision?
Overdid it a little bit with my camera.
Okay, the only thing we have to be careful of is you're on the microphone back there, and the people out there in TV land may not be able to hear you if you're speaking here. So take your time, and we'll get those assembled and get you back on the microphone.
Okay, why don't we do this? Share, and then we'll want to talk about it.
Great.
Why don't you continue?
Sure. So my wife and I, we've lived in at 115 Pleasant for 7 years or so now. Having relocated from Rhode Island, my wife actually grew up in town, and as I always like to say, she goes by the rule: all roads go through Milton. But anyhow, our proposal is to close off the rectangular addition off the back of the house so that it's flush with the front section of the house. And what we're proposing to build in this particular area that was denied is an expansion of our bathroom, as well as an entryway into that bathroom and a laundry hallway. Currently, access into the bathroom is through the living room, and we have a very tiny, I'm hard pressed to call it a closet, it's more like a nook where we have a stackable washer and dryer. So we're looking to expand. We have 3 children. Our bathroom is Grand Central Station every morning and every evening. As part of our, so what we're seeking to do is really just to close off that back section of the property. Where our house currently sits on the lot, we're kind of up against the lot line on one side, and on the other side, we have our driveway up against our house on that side. And in order for us to build, our house is, the deed says 1900, but we've been told it's probably 100 years older than that. The newer section of the house is off the back of the house, which is the only area that we would feel comfortable building off of. As part of this process, I went and spoke to a few of our abutters that directly abut our property. One of them being Mr. King. I have some signatures of their support for our request for variance.
So Mr. King is on the right side of your property? And he's the neighbor who would be most affected by your application.
Yes, that is correct. He actually lives, he doesn't live in that, he owns that property, and he lives in the house next to it on the other side. And I spoke with Mr. King a few weeks back and again the other day, and he fully supports our request for variance.
Okay, so Mr. King, just for the record, owns 111 Pleasant Street, which is the property that directly abuts you on the right-hand side, but he lives at 105 Pleasant Street.
That is correct.
And this is John E. King.
John E. King, that's
Okay.
correct.
And tell us about the other people with whom you've spoke and what their position is on your application.
Yes, I've spoken with our neighbors that abut us to the back of the property, Karen and Ray Dewhurst. We spoke with them about what their thoughts were about it, and they fully support us as well.
Okay. They live at 3 Bailey Avenue, is that true?
Yes, 3 Bailey Avenue. And I spoke with Mrs. Flaherty, who lives at 127 Pleasant Street, just on the other side of Bailey Ave, and Mary and Joe Moynihan, who live at 124, across the street, across from Pleasant. All the neighbors that I spoke to that directly abut us were in support of our application.
All righty, thank you for the petition, which is signed by the Kings, the Dewhursts, Mr. and Mrs. Moynihan, and Kathleen Flaherty, all supporting the present application. So thank you for your effort in getting that for us. What else do you have with respect to?
I just wanted to point out in the pictures that I gave to you, you can see where what we're looking to enclose, which is this rectangular little space where the window would be removed, and that's the back entrance that we're hoping to build off the laundry room and access into the bathroom. As it currently stands, the access is directly, like I said before, directly from the living room, which is not ideal when you're entertaining or have people over at the house. I believe the property was originally, the addition off the back of the house was originally built because one of the previous owners had had a fall, and so that's why we have a bathroom on the first floor, and our bedrooms are on the first floor. So, and that is the newer section of the house built, and it's built on piles as opposed to a deep foundation. So there's no basement under that.
All righty, let me see if any of the board members have any questions regarding your application. Mrs. King, please.
I do have a question. The ad reads, the setback that you're looking for is 7 feet. But I'm looking at the plot plan, and it says 6.2 plus or minus, and I just want to make sure that if we grant you something for 7 feet, that we give you enough.
Denial letter says, well, the 7 feet is, I think, to the rear.
But what about this?
Well, it's 6'2", and that's 7.
Is that gonna cover it then?
I think so. Let me check Joe's denial letter. No, I probably flipped it over. I mean, he's talking 7 feet.
Right, and I just,
Okay.
if this is built and it's 6.2, I don't have to have them.
Well, the point here is that one portion of your addition that is the closest to the lot line says 6 feet 2 inches, and the addition is somewhat at an angle, and the rear portion of the addition is 7 feet. So you're seeking basically for the front portion of the proposed addition to be 6.2 feet and the rear to be 7 feet.
That's correct, that's correct.
Okay. Do you have any other questions, Jenny? Mr.
I have no
Reiner.
questions.
Okay, I don't have any questions of the applicant. Let's see if there are any people present here. Is there any person present this evening who either has a question of Mr. Abram or wishes to speak in support of this application for variance? Okay, the record indicates there's no such person present. Is there anyone present this evening who wishes to speak in opposition to this application for variance? Thundering silence, Mr. Abram. There's nobody here who opposes your application for variance. So, do you have anything else you'd like to add, or?
I do not, other than just to thank the board for taking the time to consider our request this evening.
Good. So if you have no objection, we're going to end the evidence portion of the hearing, and it's our obligation, as you probably know, to discuss this application in open session and to vote on it, and we intend to do that here and now. Mr. Hurley, do you want to be heard?
Just briefly, it seems like a meritorious application to me, Mr. Chairman. Obviously, there's a need to put this addition on the house, and I would be inclined to vote in favor. I think we should probably vote to grant a variance up to 6.2 feet from the sideline now. I think this is just an advertising issue, and it seems to me it would be a de minimis advertising issue from my perspective, so I'd be inclined to vote to grant a variance to set it back 6.2 feet from the right side property line rather than the 10 feet required.
Okay, Mrs. King, do you want to be heard?
And I agree with that as well.
Okay. Well, certainly, I agree with my neighbors. I think, my colleagues. This application, I think you've done a very nice job preparing and presenting the application. You have a nice plot plan. You've shown us the construction plans. You've shown us photographs of the existing property and where the addition is going to go. And you've also consulted with all of your neighbors, including the neighbor most affected. And secured their written assent, which is not always easy, and it's important for the board to know that the neighbors have participated and assent to this variance application. So I agree with my colleagues. I intend to vote for this application to allow the proposed addition to be 6.2 feet from the right side property line. And what we will do is we will, and I should ask you one question before we vote, and I think I know the answer to this, but I assume that the proposed addition is going to be in substantial conformity to the plans which you've submitted, and you're not going to be making any changes in the dimensions of the plans.
No.
So we'll tie any variance into making the addition consistent with the building plans that you've submitted with us and the plot plan. So with those as a usual and customary decision in cases like this, all those in favor of granting a variance to Mr. and Mrs. Cardoza so that their addition on the right side of the property line can be 6.2 feet from the property line.
Aye.
Aye. Well, congratulations on your variance, very well presented. Thank you for your presentation. A couple of things, just as formalities, it's going to take us perhaps 2 weeks to prepare a decision, maybe a little longer.
Okay.
We prepare a written decision, it's got to be signed by the board members, and then it has to be filed with the town clerk. Even though nobody has opposed your variance application this evening, you still will not be able to secure a building permit until the 20 days have run. Once the variance has become final and there's no opposition, you can either talk to your builder or talk to Mr. Prondak. It's very important that you record your variance in the Registry of Deeds so that it becomes legally effective, okay? And Joe Prondak can help you with that, or the builders usually can do it. Beyond that, congratulations on your variance.
Great, thank you very much.
Thank you, sir.
Thank you for your time this evening.
I'll do this, John.
Great, thank you. I'm sorry. Thank you. Okay, we all set?
Yes.
Jenny, you all set? Okay, ladies and gentlemen, we're going to call to order our third and final hearing of the evening. This is on the application of the Oldfield Family LLC, appealing an enforcement letter from the Milton Building Commissioner dated January 31, 2014. Let me paraphrase the advertisement. The subject property is located in a Residence AA zoning district at 270 Hillside Street and other nearby locations. The property is operated by Thayer Nursery, and the appellants contend that the products that are sold and displayed at the nursery site are consistent with products stored and sold on farms under the Dover Amendment, and that the building commissioner, his enforcement letter should be affirmed in the sense that he allowed certain products such as let me get his letter. What's that? Oh, I've got-
You're looking for
I've got it there, the letter. The building commissioner ruled in substance that items such as clay and plastic pots for potted plants, tree ornaments, birdhouses, garden tools, hoses, fertilizers, pesticides, Christmas trees, bagged seeds, fertilizer, and mulch were incidental and accessory to a nursery operation and would be appropriate for continued sale at the premises as long as they were not sold in levels that would constitute bulk merchandising or wholesaling of those items. And the building inspector also ruled that the sale of paving stones, curbing, bluestone, limestone, flagstones, stone pavers, other construction materials, patio furniture, bocce balls, other outdoor games, wood-fired heating appliances, cooking grills were not considered to be accessory or incidental to nursery business, and those items must be, the sale of those items have to be stopped and ceased immediately. And he also ruled that the bulk storage of loam, mulch, stone dust, wood, gravel, and other products could not be sold from the premises except if they were in small bags of levels consistent for necessary for maintenance of nursery stock. But that type of equipment and materials that were consistent with the operation of a landscaping and construction business on the site were not permissible. And so essentially, that is what the appellant is appealing from Mr. Prondek's enforcement letter. Let me cover some of the preliminaries that I did in the previous applications. My name is John Leonard. I'm chairman of the Board of Appeals, and I'll be acting as chairman for this particular hearing. With me this evening to my immediate left is Board Member Virginia Donahue King. To my immediate right is Board Member Brian Hurley. The rules of the board are going to be such as at the previous hearings. We'll first of all hear from the the applicant or the appellant in this particular instance. And then we'll hear from any people who have questions of the appellant. And then we'll hear from people who wish to speak in support of the application, appealing the enforcement order. And then we'll hear from any person present who wishes to speak in opposition to the appellant's position. We're tape recording the proceeding this evening, so I would ask that before anyone speaks, tell us your name and address. Speak up nice and clear and loud so we'll have an accurate record at of the hearing if we have to revert to the tape recording in order to prepare a decision. I've basically summarized the application, but in addition to the advertisement, we'll have, as evidence at the hearing, we'll have the application, which is dated February 12, 2014, and attached to the application is the enforcement letter by our building inspector, Joseph Prondak, that's dated January 31, 2014. The board received from Mr. DeLuna's office, the attorney for the appellant. Basically, it's a memorandum in support of their position, and I assume Mr. DeLuna will be getting into these issues as part of his oral presentation, but we certainly thank Mr. DeLuna for his materials, and we'll certainly have those documents as part of the record. Did you give, by the way, Mr.
Yes,
Just bear with me.
Mr. Dunn.
Mr. Dunn, Mr. Matthew
The only
Dunn.
thing
he's-
Mr. Dunn hasn't received is I didn't realize it was a copy, is Maggie's affidavit, and I have a copy here for him when he comes up to the.
Okay, that's right. Well, why don't we pass a copy back to Mr. Dunn, so he'll have it. Mr. Dunn, do you want to come up here and join us, or would you prefer to be back with your clients? Okay, that's fine. And so Mr. DeLuna has also filed on behalf of the application an affidavit of Margaret Oldfield. It's dated April 8th, 2014, and it deals with the sales records at Thayer Nursery for 2013 and what was sold there and during the growing season and what's considered bulk sales and the like. Mr. DeLuna, I'm not going to read that because it will delay the hearing, and I know Mr. DeLuna is going to get into that in some detail. And in addition, the board did receive a memorandum from Mr. Joe Henning and Mr. Rowe's attorney, Mr. Matthew Dunn, and you've received a copy of that, and Mr. Dunn's position is that basically the board does not have jurisdiction of this appeal anymore because it's pending in the Superior Court, and if the board did have jurisdiction, that your application should be denied. But we'll be hearing from Mr. Dunn in greater detail on that issue. So, Mr. Prondak, welcome to the Board of Appeals. It's good to see you again. So without further ado, if nobody has any other preliminaries to cover, Mr. Francis DeLuna, Attorney DeLuna, representing Thayer Nursery, welcome back to the Board of Appeals. It's good to see you again.
Thank you very much.
Good, we're delighted to hear from you.
For the record, my name is Frank DeLuna with the law firm of Murtha Kalina, representing the applicant. I have submitted a memorandum. I am not going to read the memorandum, but I
Thank you.
would like to address what's therein. First of all, what you have to keep into a primary consideration is the prior action of this board requiring the removal of material from the site related to the material as it relates to the landscaping company. Now, all material that relates to the landscaping company has been removed. It's in a site in Stoughton. We've given the address to the building commissioner, and I don't know whether he's inspected it or not, but my understanding is everything as it relates to the landscaping company has been removed. In fact, all right, the landscaping company, as of this time, has no jobs. So there's no activity relating to the landscaping company,
Emanating from the site.
emanating from the site.
Yes, there may be jobs.
Well, there's no jobs. The landscaping company is not working right now. Okay, it hopefully will in the very near future, all right, but they're not doing any jobs or anything right now. Everything at the Thayer Nursery site now is Thayer Nursery. So that's, and the reason that's important is the enforcement order relates to the nursery, not the landscaping company. So if you follow my memorandum very quickly, all right, this site has been a farm since the 1700s. Mr. Oldfield purchased the property in 1963, and at the time he purchased the property, it had greenhouses, a barn, all right, and he did conduct landscaping activities himself. But more importantly, all right, and we provided ads for you, he advertised the sale of bulk earthen materials as early, that we can evidence, as 1968. So we believe he was doing it from the very get-go. But the ads in the local newspaper clearly demonstrate that he was selling bulk material. A minimum you could purchase was 3 yards to have it delivered. And obviously, if you wanted to buy less than 3 yards, you could haul it off yourself. So this use of the property, all right, dates back, all right, at least 50 years now. Secondly,
I'm sorry, could I just ask you one question? You say the sale of bulk materials, you're very general there. Are you talking?
the advertising is specific to bark mulch.
Do
Okay?
you know how much bulk mulch was sold in 1968?
I
know that may be a burden, you're going back so far.
we're lucky we're finding ads in the archives that he advertised in the paper.
It was incidental.
Okay,
Okay.
thank you.
So we have demonstrated a historic use of the property that as a nursery, that includes the bulk sales. Second, nurseries sell earthen materials in bulk as a customary use, as a customary sale within the nursery. I provided to you several similarly situated nurseries, all which demonstrate, I think there's 6 of them there.
Where are they? Are they in the materials?
Yes, they are. They would be from, I got smart this time, I actually,
You
in
numbered
the
the
corner.
pages for us.
Yes, in the corner of the pages, you'll see pages 8 through, pages 8 through 28.
Can I just ask you quickly, just to try to move it along? Are any of these nurseries on pages 8 through 28, are they located in the town of Milton?
No, they're not, but that's a very good question. Because if you go to page (46) to 49, there is a nursery, garden center, that is located in Milton, that does advertise on the internet the sale of bulk materials. And that is done pursuant to a site plan approval by the planning board which allows it, and that would be on page 44 and 45.
And I assume you're gonna tell me that the present applicant does not have such site plan approval from the planning board?
They don't have site plan approval from the planning board.
Have they ever applied for site? plan
I do not
approval?
know answer to that question. Have you ever applied for site
No,
plan?
there's site plan approval for them to erect a greenhouse. And while they were getting site plan approval to erect the greenhouse, the planning board lumped in to their site plan the mulch and bulk material.
And that was on August 26, 2002.
Yes.
And is it true, to the best of your present knowledge, that this site plan approval to Andrew Thomas and Sons is still in full force and effect? And
No.
there was no appeal that you know of?
I know that I know that the internet information came off the line today.
Okay. Good, why don't you continue, Mr.?
Okay.
Sorry, my name's Josh Oldfield,
Sure.
24 Forest Street, regarding another nursery in Milton. I'm gonna speak in reference to Eagle Farm, in which 2 of the 3 of you board members are familiar with and actually wrote the permit. It's pretty clear what you accepted with regard to Eagle Farm.
I have
And-
provided, go ahead.
And it also, with regard to Eagle Farm, deliveries on Sundays were acceptable of 18-wheel vehicles, on-site, not off premises. So across the street would not be applicable here. It's right on the property of Eagle Farm.
And do you have a copy of some decision or something for us?
It's included.
It's included, okay.
You'll
Okay, great.
figure the,
Do you have a page number for that, Mr.?
yes, you have 3, in your package. You have one from pages 30 to 37 that relates to, how do you pronounce his name?
Yeah, that's.
That is Eagle Farm. All right, you have another decision, page 38 to 41, that relates to, I'm sorry, Eagle Farm again. Another decision, Copeland Properties, would be pages 41 to 45. I'm sorry, 41 to 43.
And I find it interesting that at one point during the negotiation, you had asked Eagle Farm to move it off-site, and he came back and said he could not do that because it would have a drastic impact on his business, and he was thus allowed to return it back to his existing address.
Now,
Mr. Dorner, just gonna ask you one question. Does the appeal just relate to the sale of loam, mulch, stone, gravel, wood chips, and similar products? And all the other products are out of the
the
mix?
stone and stuff, look, the wood stoves, the bocce, the games, that's fine, they're gone.
I mean, I'm reading from the last sentence of your conclusion. It says, we should overturn the building inspector with respect to the sale of loam, mulch, stone, gravel, wood chips, and similar products. And so that's really the only part of the
Well,
appeal.
Similar products are what, and I'm gonna go into that next, if you just hold on 1 second.
Okay, but
Okay.
all that other stuff is gone. It's not,
The bocce court stuff.
Yeah, all that, the
Fine.
furniture's gone, everything is in compliance.
and just can I ask you, if you just indulge me, is it your position that the sale of those materials are protected by 48, Section 3.
Not 48, Section 3, and your bylaw.
Okay,
All right? So if we take the next step forward,
great, I'm sorry, I interrupted you.
no, your bylaw reads that the provisions of Section 5 shall be deemed not to prohibit a nursery from selling the deposit of clean earth materials on its premises on a temporary basis or from selling such clean earth material in the course of its business. So that basically says that if a nursery brings in deposits, has something deposited on its land, a earth material, then it has the right to sell that earth material. Now, the question becomes, what is earth material? So, everyone knows that there's no definition in the bylaw, so what do you do for a definition? You go to how it is commonly used. So, like everything else today, I Googled it. Earth material, and I have it on page 50. And 50, and I have another one on page 52. So, earth material can be stone, limestone, brick. It can be soil, sand, gravel. So by the provisions of 48, Section 3, coupled with your own bylaw, the nursery has a right to sell earthen materials, which would include soil, sand, bark mulch, etc., all right, from the nursery. The landscaping company can't do it from the site, the nursery can. The plain language of your own bylaw. And that's where the letter shifts a bit, all right? We believe that these can be sold as a matter of right.
But are you saying, Mr. DeLuna, that any earthen materials that are brought onto the site can only be sold through the nursery for nursery purposes and can't be hauled off the particular site and taken to some other location for use in the construction or the landscaping business? Is that true? That's not going to happen?
The language that you just used, I mean, they can sell it. They can sell it to anyone they want, except their landscaping cannot use it.
That's what I meant. If I
Their
didn't- if I
landscaping
didn't
can
say
go
that.
to another source, buy the same material, and bring it to their job
They can,
site.
Thayer Landscaping can store it at some other location off of the subject premises.
Correct.
But the Thayer Nursery can't.
They can't come back.
Use earthen materials for the construction.
Their landscaping cannot use the earthen materials at their nursery for their landscaping jobs.
Okay, I just wanted to clarify that. Why don't you continue if you
I
have
have
any more
nothing
to
else,
add?
I have nothing else to say but to answer questions.
Okay, great.
That's why we believe that the letter itself is overextending. All right?
Let me ask you one question, just for the sake of clarity here, because Mr. Prondak went to the nursery on November 25, 2013. And then on January 31, he writes this letter. The letter conforms to a request by the board that he go to the property, that he inspect the property, and that he make decisions as to what legitimately can be sold there as nursery products in accordance with the board's decision. Okay? Okay. My question is this. At any time, since Mr. Prondak conducted his inspection on November 25, 2013, to the present date, did you bring any of this information or any of the arguments that you're presently making before the board to Mr. Prondak's attention so that he could consider those issues when he was preparing his inspection report for the board.
Not to the best of my knowledge. I did not. I don't know what conversations my clients had.
Again, Josh Oldfield, I did have a conversation with Joe regarding that.
Okay, well, then we'll get into that.
Maggie had something to say, so before.
Oh, I'm sorry.
I just had a question when you were just asking us if the landscaping, if the bulk material at the nursery could be used on the landscaping jobs. For clarification purposes, I was wondering, what does Eagle Farm do and Thomas do and Coulter do? They as well have bulk material on their sites, and they as well do have landscaping services. So I'm wondering if they have to follow the same rules as we do.
Well, we're deciding your case now, and
Yeah.
we're not deciding Eagle Farms case or Thomas's case, if they have any. I am not aware of, all I can say is we're deciding this particular case, and we have the information. that
Right,
you've
so
given
you
us.
approved the Eagle Farm selling of earth materials, and
Ms. Oldfield, let me tell you this, okay? This hearing's been scheduled for 3.5 to 4 weeks, okay? And we get this material tonight, like 15 minutes, and I'm not being critical, I know how busy Mr. DeLuna is, he's a very successful lawyer. But we're given 60 pages of material, including decisions relating to other nurseries, information from the internet, an affidavit from you, without the ability to read it, to consider it, and to see how it applies to your application, okay? So all I'm telling you is, we'll consider everything that you submit to us, but nobody's going to be handing us decisions in the middle of a hearing or at the beginning of a hearing and start to lecture us about our previous decisions when we haven't even had a chance to consider those opinions and how they relate to your particular application. But I assure you, we'll read the materials, we'll read the decisions, and we'll render decisions as fairly to you as we've tried to do with other particular applicants in the town of Milton. And we'll certainly consider the information that Mr. DeLuna has presented with what other nurseries who may be in surrounding towns do. Not that there is perhaps as equal a level of comparison as what we do here in Milton, because they're not acting under the same zoning bylaws. So all I'm saying to you is we'll read these materials. We appreciate you giving them to us. We don't read the decisions with respect to every nursery in Milton prior to holding a hearing on these things. So, I think that's just what I'll say. We appreciate it, we'll read it, we'll consider it, and we'll come to a fair determination after reviewing the materials. No, I'm sorry, Brian, did you have something to say?
No,
or was-
nothing for
Okay.
the moment.
Mr. Oldfield, go ahead.
Just one question that would go a long way with me.
Sure.
When you go through this process of determining what's incidental, is it a formula you use? Is it,
It's the same test that Mr. DeLuna used. We'd look at cases, decided cases that define the term incidental or auxiliary or whatever terms we're looking at. And Mr. Prondak would then consider what is taking place on site in light of the definition of those terms. And all I wanted to point out is that when Mr. Prondak rendered his decision, which to my mind was a thoughtful decision, whether it's right or wrong, that's what we're here to decide. I'd like to know what he was presented with, so what he had to consider. Because from my personal standpoint here, if he was not asked to consider certain materials such as this, he should have a right to consider them. And that it's unfair to ask Mr. Prondak to conduct an inspection as ordered by the board, and not provide him with all of the information that you're coming around now and appealing from, because maybe Mr. Prondak would look at things differently. He's the building inspector. From my perspective, Mr. Prondak makes the first line of decisions on zoning issues. And then you have the right to appeal and come to the Board of Appeals, and when you don't like our decisions, you have the right to appeal to the Land Court or the Superior Court. So I just want to know, and I think we do know now, that Mr. Prondak inspected the property, and he didn't have this information at his disposal. I just think that's an important.
But what he did
consideration.
have is the ZBA decision, and that's how it should work,
He had the decision of
of you guys.
yeah, the decision of January,
So he based
decision of
his,
September 26, 2013.
all his decisions are based on your decision,
As to what should be incidental to,
of what's allowable and what's not.
and what's not what's part of a construction business, and that shouldn't be allowed,
Correct.
and what items are
There's,
appropriate to be
there's
sold.
4 components here,
That's
and
right.
it's very clear as to what you guys voted on, what's allowable and what's,
Well, that's exactly right, but if you're making arguments, as Mr. DeLuna is, that historically, this nursery has been selling earth materials in bulk going back to 1968, and Mr. Prondak is trying to make a decision as to whether you should be selling materials in bulk presently, and he decides that it should not be done, but those materials can be sold in smaller quantities incidental to what a nursery may use. I think that maybe it would have been a good idea to tell Mr. Prondak that, well, here's some historical information that you may want to consider in formulating your decision, and not appearing at a hearing, handing us the materials without even the board have an opportunity to review the materials and to review the previous decisions prior to his writing a letter. And then you're coming in and asking us to reverse Mr. Prondak based on information that he may not consider relevant, he may consider it important information to consider. I just don't know.
my feeling is with respect to you and the rest of the board, you have 4 decisions to make. That's it.
We do. But we're not the building inspector, and we're deciding an issue here.
But he
To
makes
trying to-
his decision based on your leadership.
He makes the decision based upon the facts that he sees and the information that you tell him when he's conducting his inspection. Maybe you didn't want to give him the information, maybe you didn't know the information, maybe Mr. DeLuna discovered the information as part of his preparation for this hearing, because he's a very skilled advocate and an effective advocate. I don't know. And I'm not being critical. All I'm saying is, I just wanted to know, and I asked the question, whether this information was at Mr. Prondak's disposal at the time that he wrote his letter. That's all I'm,
We did, when, he didn't ask, when he came out for his inspection, I walked him around and I gave him a full view of everything. He didn't have too many questions that I am aware of, and if he had them, we would have answered them. So we didn't know what he was going to write in his letter until we received his letter.
well, I understand that, I understand
so
that.
we
But if
couldn't address
you,
his
if you're
concerns.
contending that Mr. Prondak erred in his decision in saying that the bulk sale of earth materials should not take place on the premises, and you knew or should have known that they had been taking place on the premises, if we agree that that's true as a fact. All I'm suggesting is it may have been a nice thing to tell Mr. Prondak that that's your position. But let's go on with the hearing, because we're here to conduct a hearing and not, I just wanted to know what Mr. Prondak had at his disposal at that time. To my mind, it's not the job of the building inspector to go back and to look at newspaper articles to figure out what you people have been selling over the years. If you're contending that your sale of these items is proper, and I'm not being critical, but I think it would have been nice if Mr. Prondak knew that at the time he was writing his letter, but he didn't.
Well, I'm pretty sure he knew.
He did, it
knew.
was here at the hearings.
Well, why don't we'll let Mr. Prondak, from my perspective, the important thing is either you knew or you should have known and you didn't tell him. Now, why, that's not my issue. All I'm saying, it would have been helpful, it would have been nice if you had told him this. Or if it's sometime after his letter was written, you gave him these materials so that he could reconsider his letter if he wanted to. He doesn't have to reconsider anything. Joe Prondak is the building inspector. But from my perspective here, all I'm saying is to walk into a hearing like this, an appeal, and immediately before the hearing, to hand us 60 pages of materials and affidavits that were never, and he should do this, Mr. DeLuna should be doing this, he's your lawyer, but to effectively say that none of this information was presented to Mr. Prondak, but by the way, you should reverse his decision because it's contrary to these materials. I just think there's an element of perhaps unfairness there. But let's go on. Do you have anything else to add in support of your application?
No.
Mr. DeLuna, okay. My board members, do you have any questions of?
Not at the moment.
Okay, Ms. Virginia, okay. So why don't we do this? Mr. Prondak, do you want to be heard? And then we want to hear from Mr. Dunn as to his views on all of this. Mr. Prondak, welcome to the Board of Appeals.
Thank you, good evening.
Thank
For the record, Joe Prondak, Building Commissioner of Town of Milton. A couple of things. My letter, I saw my charge from the board as to go out and determine, with respect mostly to this case, what was incidental and what was not. And my view in writing this letter on the bulk piles of various materials was conservative. It's very hard to know, you know, if I go to, say, a nursery and I buy a 4-foot shrub and put it in my car and I put 2 bags of mulch in to put around it after I plant it, certainly that's accessory, but what if I go with my pickup and buy 8 bags? I mean, how do I know? So there's really no way to be sure. And I was trying to be conservative and trying to bring a finality to this whole process that's gone on for a couple of years now. So I believe that only the smaller quantities are really incidental to the nursery operation that's there, right or wrong. With respect to one of Mr. Hurley's earlier questions, there is some masonry products still on the property. So I'm not sure if they intended to bring that up tonight. I did say in my letter, again, I said products stored at their nursery such as paving stone, curbing, edging, granite, bluestone, sandstone, limestone, flagstone, concrete pavers, stone pavers, concrete block, and stone for construction of retaining or decorative outdoor walls must cease. They have a smaller, I was at the property today at 5 o'clock. There's only one bulk pile of loam currently on the property. There is a small amount of masonry products. And according to Josh, these are, you know, used incidentally or decoratively with trees that are sold. How do I know? There's a question there. With respect to some of the information that was presented, and specifically Section 5 of the bylaw that Mr. DeLuna first brought up. Section 5 of the bylaw, it regulates our fill, how much fill someone can bring into a property with or without needing a special permit from the zoning board of appeals. The part in Section 5 that says shall not be deemed to prohibit a nursery from bringing in earth materials, that refers, in other words, what that's saying is that a legitimate nursery that has the right to store and sell earth materials shall not be prohibited by that bylaw that otherwise regulates fill. So in my opinion, and Maggie did bring this up to me several months ago, and Josh brought it up today, in my opinion, that argument that Section 5 somehow allows nurseries to sell or store fill is absolutely no bearing. That's my opinion on that. And I would just like comment briefly on you know, some of the other decisions that were made. If they had brought up, you know, the other two on Randolph Avenue, in my opinion, those decisions from the board, those prior decisions are independent. And if they exclusively allowed bulk storage on other sites, it doesn't necessarily, each decision, each case stands on its own. So I wouldn't take into consideration the fact that you allowed it at Thayer, I mean, you allowed it at Eagle Farms, you allowed it at A.J. Thomas, doesn't mean you allowed it at Thayer Nursery. So again, my decision was based on a conservative view with an eye towards bringing a final resolution to this long-standing debate.
So Joe, I have a question. So as you know, oh, sorry.
I'm sorry, just, you finished, Mr.
Uh,
Clerk.
That's
Okay,
about it for today.
why don't you address your questions to the board, because we're not gonna cross-examine Mr. Prondak tonight.
So we have a compost pile. So my question is, are we allowed to sell that compost pile?
Maggie's referring to a compost pile, I believe, that is on the property at 217 Hillside. That's where they do composting, and this is an issue that was at least discussed at the board at a prior hearing several years ago.
I don't remember.
Mr. DeLuna will say that, and he's brought me evidence that he's got approval from the state to, I'm not sure which agency.
Approval from this board.
Right, but I don't
for
think
the-
that's,
Specifically
remanded.
composting. So anyway, so they do manufacture compost at part of the Thayer site at 217, so I think it is there. I don't know if,
I don't think it's relevant to this particular hearing. It's not before us. There's no question regarding that. It didn't come
Okay,
up
so-
at the previous hearings. So why would we address that? Why would you want us to address it? If you're operating a compost facility,
So my
And-
question is, can we bring that compost off-site, have it processed, then bring it back on-site to sell?
you're asking the wrong people. We're not in charge of your business. We're not regulating the compost. We're not deciding that. It's not before us. So why would you even want to bring that up? Nobody's seeking to prohibit that. We're trying to decide issues based upon the strict decision and to keep our determinations within the confines of the decision and not to start looking at everything that you do. You don't want us to do that. We don't want to do it. If somebody presents that issue, we'll deal with it. But it's not before us, in my view. I'm certainly not going to go into that as part of this hearing. So I think that you should do what you're going to do, run your business.
Well, that's what we're trying to do.
Well, that's right, and we
And
want you to
it's-
comply with the zoning bylaw as we see it, and you can get judgments from the court, or the appeals court, or the Supreme Judicial Court, or,
Yeah, but we don't want to go that far.
well, maybe you don't, and maybe, I think all Mr. Prondak is trying to do is to try to render a decision that was consistent with how he viewed our decision. That's all we're doing. So,
As I,
Mr. Hurley.
as I understand your letter, there were 4 paragraphs, so four separate issues. The first paragraph was in favor of their nursery. It said this stuff.
Found some things that I
all
think
this
are clearly
stuff, you can sell it as incidental. Paragraph 2, if I understand Mr. DeLuna tonight, is no longer an issue. Because of all the things you said, you must stop selling, he agrees that they will. It's not part of that, at least it's not.
With the exception of the
top half.
granite, bluestone, and.
I'm sorry.
flagstone,
Okay,
the
that's-
first sentence.
That directly relates to your section 4A of your zoning bylaw. And I think part of the disagreement that you will decide is whether that section is applicable to the materials at the nursery. Obviously, the nursery is saying that section is applicable and exempts the nursery or allows the sale of that product. Mr. Prondyke's position is that's not the case.
No, but paragraph 2 of the letter relates to bluestone, sandstone, limestone, flagstone, concrete.
And
Yeah,
And-
he's
and I-
not at the bulk material yet.
I thought you said to me earlier that that's off the table.
that's where I said we have to stop that because I would address it, and I did address it, because your bylaw refers to earth materials. All those materials are in fact earth materials, which are protected by the zoning bylaw.
Okay, I misunderstood what you were saying earlier, so.
The
so
other materials, I agree, the furniture, the bocce, the games, the.
Pavers, concrete blocks.
No, that's, if you look at the definition of earth
It said,
material.
it said naturally occurring, and
No,
the last time I checked, pavers aren't naturally occurring.
Please refer to the exhibit that I preferred.
I'm referring to your definition that you gave us.
It does talk about
Naturally
bricks and,
occurring
bricks and
materials.
other materials.
Okay, so so you do claim the right then to sell granite, bluestone, sandstone, pavers, retaining walls, concrete, all that stuff?
No, we don't sell that stuff.
But, okay, I want to understand what's at issue here tonight. Are you claiming the right to be able to do that or not? I thought we were down to, frankly, the issue of whether you could sell loam, mulch, stone
Correct.
dust, sand, gravel, wood chips, and period.
So you're taking,
Yeah.
you're, for the record, you're
Discussion.
taking that off the table?
Yes.
Because that makes, to me, that makes this an easier decision. Because then the question becomes, how much of that is really incidental to the business? And I don't exactly know how to define that. So if I go to Thayer Nursery tomorrow and I say, I want to buy 8 maple trees for my front lawn, and I'm an idiot, I don't know how to plant them, I don't know how to take care of them, would you guys bring all the dirt that you need to do that? That's probably gonna be more than a few bags of dirt to do that. Now, I would consider that incidental to their business. So, and presumably they could have some piles of that stuff on their property. It wouldn't have to be in bags for it to be incidental. So that's sort of my dilemma. I don't know what the right number is, how many cubic yards of material.
Mr. Hurley, if I may, I've been informed by my client that they're willing to take the paving stone, the curbing, edging, granite, bluestone, sandstone, limestone, flagstone, and concrete and stone pavers, concrete block, and stone for the construction of retaining a decorative outdoor walls off the table.
Okay, so paragraph 1, we have no dispute about, because Joe doesn't disagree. Number 2's off the table. Number 4, I don't really know what's going on there. That has something to do with trucks. Has that been resolved, paragraph 4 in his letter?
Yep.
Okay, so we're down to number 3. And to my mind, it becomes a question of quantity, because I accept the premise that in certain quantities, these materials are incidental to a nursery business. I think they are. I mean, if I go to a nursery and I buy a lot of stuff, I'm expecting you to give me the stuff that I need to plant it, or to have somebody plant it for me. So I would consider that incidental. Do you agree with that?
I do, but just to add to the dilemma a little bit, I asked Josh Oldfield today, for example, if so-and-so landscaping were to come to, say, a nursery to buy a pickup truck full of mulch, would they sell it to him? And the answer was absolutely yes. So I think what Thayer is saying that I don't wanna argue their case for them, but I think they're saying that whether it's relative to planting these trees that they sell or not, that mulch is incidental to the nursery.
The way I view it is incidental, it's accompanying but not a major part of something. For example, it's the field worker who deals with real problems, paperwork is incidental. Compost, screen topsoil, mulch are incidental to the horticultural components of anyone's house. Whether it be lawn, flowers, trees, shrubs, and evergreens.
Okay.
I think it may be informative to note on Maggie's affidavit, the volume of what we're actually talking about. All right, the volume is relatively small, and the sales volume, in relationship to the operation.
6.5% total, is that, do I read that correctly?
Yes, and I think she broke it down
She did,
as to
yes.
what percentage of what material it actually is.
Now that we've sort of limited this dispute, if you will, to one paragraph and basically one issue, I would find it helpful to hear from Mr. Dunn as to what his position is with respect to these items. Does that make sense?
It does make sense, but just let me ask one question before I don't forget it. Based upon your historical use of the property, can you tell us, with respect to the mulch and the loam, on average, how much during the growing season and during your nursery selling season, how much of those materials would generally be stored on the nursery site in terms of quantity? Can you give us any estimate as
At
to
the
that?
most, twice of what Joe saw today.
How many cubic yards is that?
A trailer comes in 55 cubic yards. Joe saw, you have mulch. Joe saw 30 yards of screen mulch.
But just to follow up on that question, how many different products are we talking? We're talking mulch, stone dust,
Mulch, loam,
loam?
I guess compost
so-
and stone. Compost is in
I mean,
here.
if there's 5 different products, then 5 times 55 is several hundred yards.
No. Trailer of loam, stone is in 28 cubic yard increments, one per, so that's, say,
I think that-
75 yards.
I think that's what the board is asking.
So 75 cubic yards plus 50 plus 60,
And what's the 60?
the screen loam.
Okay. And where would they be stored on the property customarily? Are they away from the applicant's,
Yes,
strike it, the Mr. Joe Henning and Mr. Rowe's residence, are they?
correct,
Are they against the barn?
yes.
Tell
And
them-
Joe-
Tell them that.
Joe can see, we've positioned them against the barn, so the barn can act as a buffer. It's approximately, Joe, what would you say, 1,000 feet to the property line?
I wouldn't be that, 'cause maybe 500.
No, well,
Maybe
the
not
barn
even.
itself is
Yeah.
40.
Which side of the barn are they on? I remember being on the property.
On
The
the-
far side of the barn?
Correct,
So
toward,
that the barn is shielding the Joe Henning Rowe residence from the compost and the.
Correct.
Is it between your house and the barn?
yes.
Just for clarification, I went there today, there was the pile of loam that I saw today was on the, as you face the entrance to the barn, to the right of the barn. So in Mr. Johanning, Mr. Rowe's property would be to the left of the barn. That is a new location, I had not seen it there before, and Josh told me that any other piles, if allowed, would also go along that side of the barn. So all those piles which were previously stored much closer to Mr. Johanning's and Mr. Rowe's property apparently are now, and again, I just saw this today. The location is new.
Okay. And are these materials, the stone, the loam, and the mulch, are they covered with a tarp or something? Or are they wetted down, or is there some way that you,
We would agree to cover them with a tarp.
So they don't blow all over the place, so
Correct.
it's not dusted.
Can you cover the compost safely?
With a mesh-type tarp, yes.
All right, it's not gonna be a waterproof top.
No.
No, but it'll prevent dust
Yeah.
and debris.
It has, the compost has to breathe so it doesn't, so it can break down.
Won't catch on fire.
Correct.
Spontaneous combustion or something like that. But there is some way that you can cover the materials.
Yes.
So that neighbors anywhere around the nursery aren't adversely affected.
Correct. The products that would have an odor.
Yes.
Or dust,
Yes,
yes.
okay. Mr. Dunn, do you want to join us and join the conversation? Mr. Dunn, would you do me one favor and you just grab the microphone? Slide it down in front of you. Board of Appeals.
Thank you. Thank you for having me again. My name is Matthew Dunn. I represent Philip Joining and John Rowe. They're direct rear abutters to Thayer's property. Their home is located at 23 Parkwood Drive in Milton. Before I begin, I have a few photographs that were taken on Friday. I guess there was some representation that the stone materials and other, I guess, non-dirt, loam type materials have been moved off-site. These are from Friday.
Have you shown these to Mr. DeLuna?
I don't think I have.
Okay, would you please show them? Thank you.
And I have I'm not sure if you have a copy of my memo that I faxed over.
We do, and we thank you.
Also have a copy.
We're moving them.
Thank you.
That's prior.
So it doesn't go to sort of my main argument, but it's sort of indicative of
We're in flux.
sort of
Moving these over.
what's been happening on the property. If you look in the photograph, the first photograph, there's a dump truck. Then there's also several of the items that Commissioner Prondak expressly prescribed in his January 31st order. I think it could be identified on paragraph number 2. So, any representation that those items aren't being stored on the property, at least as of Friday, that's incorrect. I think maybe part of, and I'm speculating here, but maybe part of the problem in sort of trying to parse out what materials are used in connection with the prescribed landscaping business and what are actually used as part of the nursery may have had to do with the fact that much of the landscaping equipment and materials remained on the property, to date. They're on the property. If you look on the second photograph, there's a bobcat, and there's another photo of a dump truck. So there's been no real attempt to comply with this board's decision of September 26th. And, the board used the word immediately in 3 separate paragraphs as part of its order. And here we are, as of April 4th or 5th, and it's still not taken effect. So, as this board is aware, the September 26th decision was part of a very lengthy, contentious hearing process that lasted over 5 months. This board issued a thorough decision as to what activities were allowed and what activities were not allowed. And what's being attempted here is a recasting of the very same materials and uses that this board prescribed as part of the landscaping business. They're now trying to recast it as, now it's part of the nursery business. the arguments that my brother made are more appropriately directed to the Norfolk Superior Court at this stage, with all due respect to this board. There's a process under 40A in which disputes just like this are supposed to be adjudicated. And it requires a decision by this board, which was appealed by Thayer. Now, Thayer is saying that the farm exemption allows it to sell the items that it's contesting that in Mr. Prondak's decision. Well, what we're talking about here is really Thayer's, it's not even the second bite of the apple, it's really the third bite of the apple is what they're attempting here. They had a full opportunity before this board back, over the course of 5 months through September, to make these arguments that, hey, these are real, these aren't part of the landscaping, they're part of our nursery. And there wasn't, I sat through all of it, and as did you, and there was no discussion about that. So the decision issues expressly stating that the storage of mulch, loam, fertilizer, stone pavers, stone dust, and gravel as part of such commercial landscaping, commercial construction business are prohibited. Theirs to cease and desist from selling and storing mulch, loam, fertilizer, stone pavers, stone dust, gravel as part of the commercial landscaping and construction business, and that these construction-related materials be removed from the property. Again, this is September 26, 2013. The photos I gave you were from April 5th or 4th of 2014. Those materials are still there. So the decision of September 26th is the law of the land until a Superior Court judge says that it's not. And Thayer recognized this back in October. And they filed a motion for a preliminary injunction seeking to enjoin or stay Mr. Prondak's enforcement of your decision during the pendency of the appeal. And that was thoroughly briefed. Oral arguments were heard. And Judge Davis issued a decision on October 28th, 2013, out of the Norfolk Superior Court, saying plaintiff, which is Thayer's, motion for a preliminary injunction is denied. Plaintiff's challenge a September 26, 2013 decision of the Milton Zoning Board of Appeals directing them to cease and desist from using the subject premises in Milton, Massachusetts to operate a commercial landscaping and construction business and various other related activities, including the storage and sale of materials used in plaintiff's commercial landscaping and commercial construction business. And then they go on. They argue that their commercial landscaping construction business, which operates out of the same location and which has grown significantly in volume and revenues in recent years, constitutes protected agricultural or horticulture under the Dover Amendment. The court, at least at this preliminary stage of this action, does not agree. Commercial landscaping and commercial construction cannot reasonably be characterized as agriculture or horticulture for purposes of the Dover Amendment, nor can they be fairly described as incidental to such uses where, as here, commercial landscaping and commercial construction now comprise plaintiff's primary use of the property. And the judge cites the Henry versus Board of Appeals of Dunstable decision. Accordingly, the court finds that plaintiffs are unlikely to succeed on the merits. So this is an issue that this court, that the Norfolk Superior Court has recognized that it has jurisdiction over. And I think that the case law goes back to the 60s, talking about if they're upset about your decision of September 26th, then under 48 Section 17, the avenue to get clarification as to what they can do or what they cannot do is vested exclusively in the Norfolk Superior Court at this stage by their filing of their appeal. So respectfully, this board doesn't have jurisdiction to craft the type of relief that the Oldfields are asking it to craft. If they want to argue that your decision, the prohibition of the materials that can be stored on the property, if they want to challenge that, that challenge needs to be made and has been made in the Norfolk Superior Court. So the cases that I cite, like I said, they go back to 1960, follow up in 1963. Just the exclusive remedy of a person aggrieved by a decision of the Board of Appeals was or is an appeal to the Superior Court. And that's the Lincoln versus Board of Appeals of Framingham case and the Smith versus Board of Appeals of Plymouth case. So, that's really sort of point one with regards to our opposition to the present appeal is really jurisdictional. Point two is that I think Commissioner Prondak sort of, he sat through the hearings back over the course of the 5 months. And I think, from my reading of this, had an understanding as to what activities the board was trying to prescribe and what activities the board was trying to allow. And I think that, the first paragraph is very reasonable. I think that it sort of grants the relief that there is arguing for now. Some of the arguments about theirs being able to sell bulk quantities of the mulch and the loam and I mean, now we're having the same discussion about, is that part of landscaping? I mean, if you're installing or planting trees and using materials that are stored from one site and installing them on another site, I mean, to me, that's landscaping. But, that's not really a decision for me to make. That's a decision at this point, for the Norfolk Superior Court to make. But sort of going back to argument number two, is that, Mr. Prondak's decision is very reasonable. If you take out, if number two really isn't on the table anymore, and I seem to think that it is, based on the photographs that are before you, that's something that shouldn't be, it's expressly prescribed. I don't see how it relates to a nursery. I mean, you have to start from the premise that the only activities that are allowed there are a nursery and uses that are accessory to a nursery. The landscaping is gone, the construction is gone, and if those uses want to be contested and in materials that are used accessory to those want to be contested, again, that's in the Superior Court. So Commissioner Prondak's decision is reasonable, and I'm not going to waste any more of the board's time by repeating things, but this is a fight that belongs before the Superior Court. The arguments that my brother made, they could be presented on a motion for summary judgment or at a trial, and we can have that fight in Norfolk, but the case law is pretty clear that that's where it belongs. So that's my presentation and my opposition for my clients, and I'm happy to answer any questions if anybody has any.
Sure.
I take it you would consider this letter, this 13114 letter, to be a non-appealable event. So, for example, if Mr. Prendergast had issued a decision that you didn't like in some regard, you wouldn't have been able to appeal that either. Because if you're right, if the Superior Court has exclusive jurisdiction, I'm not disagreeing with you. I haven't really thought about it because, quite frankly, like Mr. Leonard tonight, I was not amused to get all this stuff at 5 o'clock today. I work all day in a law firm too, and I pretty much had it with this stuff by the time it gets to be 5 o'clock on a Tuesday, and I was not amused to get all this stuff. And I haven't read it all, and I don't think that's fair, but that's neither here nor there. But, so I take it you don't consider that, I don't know what you consider this letter. What are we to do with this? Ignore it? No one can appeal from it? I don't know, what do we do with it?
I think the appeal itself was improper. It's, again,
This decision of Mr. Prendergast is not appealable under 48.
I think it's unnecessary.
Is it appealable? Is it an appealable event?
In my opinion,
You say no.
I don't think it is. I mean, I don't think that the the precipitating appeal, or I'm sorry.
The underlying appeal, you mean?
The appeal of that.
The September appeal.
Everything that is, I don't really know how to answer that question, to be perfectly honest.
Let me
with you.
ask you another question. I think it's an offshoot of what Mr. Hurley was trying to say. We entered a decision on September 26, 2013. Thayer Nursery appealed. That's pending in the Superior Court.
Yes.
Okay. Then on February 11th, we entered another decision on firewood issues. Thayer appealed that. That's pending in the Norfolk Superior Court.
Yes.
Now, as part of our September 26th decision, we requested that Mr. Prondak go out and do the inspection which he conducted.
Yes.
Okay. That inspection is set forth, the results of the inspection and his conclusions are set forth in this January 31st, 2014 letter. But that letter comes to the Board of Appeals after the proceeding had been filed in Norfolk, okay?
Yes.
Isn't that right?
Yes.
So what I see this is, and so Thayer seeks to appeal from this enforcement letter, I think in part, to preserve their legal rights in the Superior Court, because this isn't part of the Superior Court record, and presumably wouldn't be, unless the issue comes up, and Judge Davis, who's no longer there, as you probably know, I looked to see who was there. Judge Paul Wilson is there now, starting on Monday. Wouldn't Judge Wilson say, well, what does the Board of Appeals have to say about this? Rather than, he doesn't want to conduct a hearing dealing with this. Wouldn't he want to see what the board decision is on this appeal? So we can handle it as part of the, as incidental or accessory to the original appeal that they have filed?
Well, if I can address.
Or he could remand it back to us, and all of a sudden, we've washed this away, we're gonna have another hearing to go over the same thing again. It doesn't make any sense to
It
me.
doesn't make any sense. You know, I think that, keeping this in a single forum instead of doing, merry-go-round and forum shopping makes a lot of sense.
Right, but if we decide this issue tonight, and I don't know whether we're gonna do that, to be frank about it, we never seem to be able to. But if we decide this issue tonight, one way or the other, somebody's going to appeal, and it's going to be part and parcel of the proceeding in the Superior Court, and the Superior Court judge is going to have the right to say, the Board of Appeals had no jurisdiction to enter this, so I'm not gonna pay any attention to it. Or he could say, well, this is helpful to me because I see what the board thinks of this, and enter it as part of his decision on the overall case.
Well, I think to address Mr. Hurley's question, and he sort of after thinking about it a little bit, the grounds for the appeal of Commissioner Prondak's letter are what makes it improper, in that Thayer is saying that they're entitled to sell these under this agricultural exemption. And whether or not Thayer is entitled to the agricultural exemption is a live issue in 2 Superior Court cases. So that basis for the appeal is improper, because that's a matter that rests exclusively with the Superior Court, if that makes any sense.
Well, I think I know I know your argument. I'm not sure I understand it fully or want to go there, but let me, Brian, do you have any further questions?
No, I mean, when I first saw this a few weeks ago, I have to admit, my immediate reaction to this was, are you kidding me? You're back here again. I couldn't believe it, frankly. But as I've thought about it a little bit more, and as I look at this letter, it strikes me that, I mean, one way you could look at this is not being a decision under 40A, Section 8 and Section 15, but rather just what it is, a cease and desist order. Maybe it's not an appealable event. I don't know. It's very, very bizarre. But what would have happened if he didn't issue a cease and desist order? Then you probably would have appealed. Well, maybe you would've gone to the Superior Court and asked them to issue an injunction, which is probably what I would've done, rather than come back here. Okay, I don't know the answer to this question, it's not something I've encountered before.
So I mean, so what what I think is, again, and I'm reiterating something here, but what I think is important is you have materials that are being stored on the property that were expressly prescribed by this board. And now there's an attempt to recast those materials as being used for something else, when there's testimony here today that they can be used as part of a landscaping for the very purpose that they were prescribed for in the first place.
Right, but I think what Thayer is saying to us here is that we're not going to use these materials for the landscaping business. We're going to use them for our nursery business, and they're arguing to us that they've historically stored and sold this type of material incident to the nursery business. And I think their argument is that a decision related to a construction and landscaping issue, and not to basically fundamentally try to change their ability to conduct a nursery business. And the ancillary part of that is, well, if we adopted some type of the compromise that's shown on this letter, is it consistent with what they've been doing in the past? Is it nursery business? And I guess thirdly, but not necessarily in third place, is what type of effect would allowing the limited storage of these materials and use as part of the nursery business have on your client's property? And they've told us that they've put these piles on the right side of the barn, and they're 500 feet or something like that from maybe more from your client's property. So the argument is that it has no effect on your client's property, and that to enforce this order would have a dramatic effect on their nursery business, which Mr. DeLuna says is a protected, is protected. And it's a question of drawing lines, isn't it, as to what's incidental to the nursery business, and where do you cross the line is to now you're not running a landscaping business on site there, but that type of activity as a nursery is more consistent with a landscaping business than running a nursery.
Well, I mean, with their description, and I guess this is subjective, but from my viewpoint, their description of the uses of the material are uses that are associated with a landscaping business. So what you have is apparently.
Why is that? Because if I wanted to put in 5 trees, as I think my brother suggested, and they're gonna deliver 5 trees to my home, and they're gonna decorate around the trees with stone or something like that, why is that landscaping and not nursery, as compared to the nature of the use, which we prohibited in our September 26th, 2013 decision, which in our view, I know Mr. DeLuna disagrees with it, at least in our view, was running a full-scale construction company and large-scale landscaping business from a nursery site. We thought that was inappropriate.
Well, I think what you're describing, respectfully, is a landscaping component. I think a nursery is raising
Daffodils and little plants and
and
pots.
trees on premises. It's not taking those trees, delivering them to an off-site location, installing them, and then dressing up the area around it. I mean, I think that is a definition of landscaping.
What if I was gonna do that as the homeowner, and I just wanted to buy the accessory stones? And, well, let me, like this, you're not gonna be able to answer this question. I don't mean to be a smart guy. But if it wasn't 5 trees, what if it was 3 trees? So if it was 2 trees, is that landscaping or is that nursery?
If you're buying the trees.
If I'm going there and I say, I need 2 trees for my front lawn,
Okay.
and I want some stone to put around them, and I want some mulch. Now, is that landscaping, or is that nursery?
I think if you're an individual and you're doing that yourself, I think that that is nursery. I think if you're having employees take the items off-site, install them on the property, and, you know, maybe it depends on the volume.
It does,
You know,
it does, and
so-
that's the difficulty in drawing the
So
line.
what I see happening here, it appears to me, is that you have the equipment for the landscaping company, maybe some of it, I mean, some of it is still on the property. You have the equipment being moved off-site to run a landscaping company, and you have the materials remaining on-site. And so you're not, there's still a landscaping component that's being operated here, and it's being done under the guise of a nursery. So, I mean, this is precisely why this should be in one form. Should be in the Superior Court. To
Well,
have
it
this-
is, it is in the Superior Court, and to be frank, no matter what we do tonight, and we'll probably end up continuing this hearing, but when we render a decision here, whether we say we have no jurisdiction, we have jurisdiction, we allow this, we don't allow that, it's all gonna be before the Superior Court judge. De novo, to the best of my knowledge, the judge can look at our decision and say, well, this is a reasoned attempt to resolve issues. Or the judge can say, these people have no authority to be doing this. This is my job, it's in the Superior Court. You're gonna get an adjudication of these issues, and the question is it helpful to the parties here? Rather than having Mr. Prondak's letter and saying, well, this is the fiat, and this is gonna be imposed, and let Judge Wilson do whatever he wants with it. Or if some type of accommodation, a reasonable accommodation, if anyone can agree on that, can be made on these issues, whether that makes more sense and saves you another day of trial. And where you draw the line here, where it becomes nursery and landscaping, whether it's 2 trees or 1 tree, or the size of the tree, I think those questions are not easily defined, from my view. Let me do this. Mrs. King, do you have any questions? Do you want to weigh in on this? Okay. Mr. Dunn, do you have anything further that you'd like to add? You want to talk with your clients for a second? You certainly have the opportunity to do that. Mr. Oldfield, when they come back, you can have the floor.
May I speak before my client,
you can.
please?
Of course.
We have nothing further.
Okay. Mr. Deloney, you wanted to be heard.
Just a
You
few,
want to stay there, Mr. Dunn?
Sure.
just a few bullet points to what Mr. Dunn said. First of all, our position is not solely under the agricultural exemption. I think it's under the agricultural exemption as well as the bylaw, which is very, very important in this instance. Number two, the Zoning Enabling Act was a little bit different than the Zoning Act. And I believe under the Zoning Act, Section 8, any person aggrieved by the decision of the building inspector has a right to come before the Board of Appeals. So had we not come before the Board of Appeals, I guarantee you the stop work order or the cease and desist would be waived in court and say, look, they get issued a cease and desist and they didn't appeal it to the Board of Appeals, and then our rights would have been lost. So I think the statutory process requires us to come before you. And I'm sorry that the brief got to you, or the memorandum got to you today. This is one of the busiest times for nurseries, and to assemble information is very, very difficult for them. They're about to embark on the busiest time of the year. So the timing is poor, and I apologize for the timing it got before you.
Right, and Mr. Dillon, let me say this, even though we've expressed concern and maybe some distress at receiving the memorandum late. We understand that you've been acting in full good faith here, and that you were not seeking to drop a memorandum on us at the 11th hour, so that we'd act precipitously. I mean, these hearings go on forever with Thayer Nursery, much to their dismay. So we certainly have the opportunity to continue this hearing if we want to do that, and read and consider everything that is in your memorandum, and we'll do it. So don't be overly distressed. We appreciate the time pressures that you're under. Why don't you continue?
With respect to the recitation of the judge's order or the judge's decision, first of all, it's a preliminary injunction. All right, so the standard, the judge will articulate what the standard is as the judge so did. But listen to what that language was. It concerned the commercial landscaping operation. All right, without the benefit of the pictures that were tendered tonight, one of the first things I indicated to this board was there is no work right now for the landscaping operation. If there's a truck on the site, it's not commercial landscaping. They're using that truck to move material around the nursery. It wasn't, for nursery purposes, it wasn't going to a commercial site. Right? And by the way, bobcats are part of nursery machinery. It's what farms use now. The little farm-all tractors that I use are obsolete on the nursery. And nothing that appears on the site now, is going to a Thayer landscaping job site. This is all material that would be sold vis-a-vis through a nursery. And, I know I may be different from some people, but I bought compost last year. I bought 30 yards, all right? That's 3 dump truck loads for 2 of my flower gardens. I bought 20 yards of wood chips. And these are necessary. I'm just a gardener.
You must have a fabulous residence, Mr. DeLuca.
But I
know
mean,
it's
people
probably gorgeous.
people buy this type of material in that quantities. It's not unusual. So
From nurseries.
from nurseries, I called my local nursery, Clark Nursery up in Danvers, and asked them to deliver.
They would have given you a better deal, Mr. DeLuca.
But I would have been killed in the traveling cost. I guess I'll back off, and I know Josh has something to say.
Sure, Josh Oldfield, 24 Forest Street. We recognize what landscaping is. And in our minds today, landscaping is putting one pansy in the ground. Starts there and goes up. We do landscaping off-site. We do have customers who buy larger quantities of mulch. Dr. Kenny is a prime example. He'll buy 20 or 30 cubic yards of mulch and spread it himself. So what I'm saying is, we understand what landscaping is, cease and desist means, and we're not operating at 270 Hillside Street. Do we have some equipment that we need to operate the nursery? Yes, we do. We always will need equipment. And as new equipment evolves and comes out, our goal is to be able to purchase more updated equipment. So those are sort of the facts and the reality. So if one sees a truck or a bobcat or any piece of equipment on the property, it does not mean we're landscaping on the property.
I appreciate your comments. Let me ask you one question. You don't have to answer it if you don't want to. How do you draw the distinction between a client of the nursery who wants to buy 5 trees and the mulch that's necessary, as to whether that's nursery business or landscaping business, and does it become more landscaping if they buy 7 trees or 10 trees? Or is it still nursery business?
Landscaping to me is a service. It's an actual installation. It's manual labor. So if, as Josh pointed out, if it's planting one pansy and you hired us to dig one little hole, then that is an installation charge. It's a service.
So are you saying if I bought 5 trees from you, and I did not want to install them myself because I'd end up killing the trees, and I asked you to install the trees with the necessary fertilizers and loam, that you would decline to do that because you'd be engaging in landscaping business?
No.
No, we would buy the trees,
You'd sell me the trees,
yes,
and would you put the trees in the ground?
yes.
Okay, would that,
Not from Thayer Nursery,
from somewhere else?
yes.
Really?
You would have to hire there, you would have to hire, there are 2 entities.
You'd say to go to my contracting business or my landscaping business in Randolph or Stoughton, wherever it is.
Correct.
And you'd do the deal through there.
Correct.
And it wouldn't be done on site at, in Milton.
Correct.
And would that be
So
true?
would those
Even if
guys
it was-
drive from Randolph and pick the trees up in Milton and then bring them to my yard? Is that how that would work?
Well, this is the
Seems a little
confusion.
circuitous, but.
Yeah,
Yeah,
I
that's-
don't know. The way that we've always presented this, that it was going to be an enforcement nightmare, and I had asked that question previously, and you instructed me that it wasn't really your place to tell us how to run our business. But we've known from day one, and we've tried to bring it up, that it's going to be a nightmare for Joe. We have 2 successful independent businesses, and that is why we need clarification for you, because we don't want to be doing the wrong thing. We don't want to be here.
No, but I think what Mr. DeLuna, if I understood his argument, what he was saying, is that the sale of 1, 2, 3, 4 trees from your site in Milton was really nursery business, and it's not the landscaping business. And if you're telling me that if I was going to plant the trees myself, then it's nursery. But if I was going to have you plant the trees because I'm unable to do it, then it's landscaping.
Now, the Thayer Nursery would sell the plants to Thayer Landscaping,
Correct.
off-site.
Just as it would sell the plants to any other landscaping entity.
Okay. Well, on the other hand, if I told you that my son was home from the Army and he needed a workout and he was going to install 3, he was going to buy the trees, you're going to deliver them, he's going to install them, that would be nursery business. True?
Correct.
Okay.
So why don't you store the mulch in Randolph? If the commercial landscapers in Randolph, why don't you store the mulch in Randolph?
More space, more money, comes a
And-
financial burden. And our goal is not to sell the property, but as we keep getting squeezed by this board, we're thinking of alternatives, to tell you the truth.
When you're kind of taking away our ability to make money, it becomes very challenging.
Nobody's intending to take away your ability to do
No,
anything.
we're just stating the facts.
It is.
It may be reality, but it's a question
Right.
of how the bylaw should be fairly interpreted, and you've got your rights, your legal rights, which are preserved by a good lawyer. A terrific
Mr.
lawyer.
Can I
Miss-
just
I'm
ask
sorry.
you one more question? Does it, I mean, having gone through this process tonight, it just strikes me that your main reason for bringing this appeal was you didn't want somebody to say that somehow you would waive something and that you were stopped or whatever the right buzzword is. But the reality is if we did something different now, we'd effectively be overturning ourselves.
No,
If
because
we-
we're
if we said-
talking,
if
we're
we-
we're talking the nursery versus the construction.
No, but we said commercial landscaping is not permitted.
We did.
We did,
Right.
right? And you've basically abided by that,
Yeah.
as I'm learning tonight. So, and it sounds to me like this is still undeniably landscaping. this mulch and loam, and I mean, that's all part of a landscaping process.
Their nursery is not used, their nursery will use the plant material, the stock. If their nursery needs mulch, it will come from another source.
It won't come from this site?
Possibly, if I can negotiate a deal, yes.
But there's no reason for us to reverse our decision, I guess is
So,
what I'm trying to say.
but I would,
I understand that.
I would
if you-
say
If you
to
manage
you-
to avoid the decision by rearranging your business, then great, but
I would say to you, if you felt that it was in our better interest in your minds to rent space, additional space at the same location for mulch purposes, I would do that. That's how important this is to me.
I think it's a safer course.
For the landscape.
For the landscaping.
For the
landscaping.
landscaping business.
But
Yeah.
if you called up and you needed 20 yards at your house, then you would call the nursery, and the nursery would deliver 20 yards of mulch to your house from 270 Hills.
Why wouldn't you deliver it from the landscaping business?
To avoid the issue.
It completely avoids the issue that way. Aren't some of the other guys doing that? Aren't some of the other?
They're all on site.
They're all on site. Jason even said, even though we don't like to bring up other permits, it's clear as day once you dig into his permit. He says it would have such an impact on his business being across the street that it would be detrimental, and he negotiated that with you folks.
But Coulter doesn't store, does he, in Milton? I thought he had it over in Hyde Park now.
No?
No, he's back on site.
Well, he doesn't have wood there, I know that for sure.
Yep, wood is off-site.
Anyway, okay.
If I may make a suggestion, could we continue the matter, giving the board an opportunity to digest the materials submitted to them and perform a site visit at their nurseries? Because obviously, materials have been moved around from the last time you saw it. All right, continue the matter, close the matter at the next meeting, and go into deliberation.
It's fine with me.
Well, look, that's fine with me, to be frank. I think I'd be doing everyone a disservice without the opportunity of reading the materials and reading these other decisions. And I think we want to do this sooner rather than later.
Correct.
But on the other hand, I want to express the opportunity here for Mr. Dunn and his clients, if you want.
I just,
to
before
respond to
before we continue, I
Sure.
have some confusion, I guess. So, if what they're talking about is storing landscaping material on site, right, and using equipment off-site to deliver and install that material, right, isn't that part of the landscaping business?
I think,
mean-
unless I
I mean-
misunderstood,
And
Mr.
that's prescribed in your order. So if they want to change that interpretation or that order, that's an issue with the Superior Court. I mean, that they're asking to change a provision in your September 26th decision. So that's not something, respectfully, that you can do. So there's no reason to have another hearing. There's no reason to do a site inspection. They've already told you that they use the material for the landscaping business. So
I don't think that's what they said at all. Maybe I'm dead wrong. My interpretation of what Mr. Oldfield just said is that even though he doesn't want to do it because it's an additional expense, presumably rent and space, that he would be willing to take the large quantities of mulch and whatever else we have here.
he was already ordered to do it.
But just stay with me, and move those materials to their landscaping business, wherever it is, off-site here, and maintain on-site smaller quantities of those materials, which would be sold exclusively for nursery purposes, as Mr. DeLuna says they've been doing for years. I think that's what he's offering to do.
Unless I'm losing my mind, this is something that we've already talked about, and this is already something that they've already been ordered to do. So what is the point of
Well,
us
the
continuing?
point is, I think what they're saying is they'd be abiding by the tenor, if not the exact words of what Mr. Prondak was saying here, is that they would not be selling large quantities of these materials from this site, and their smaller quantities would be used for landscaping, for nursery purposes. But if somebody wanted bulk materials, that they would sell that to them from their off-site landscaping business. That's what I thought he said.
Right, but that's what they're already.
That seems consistent with what Mr. Prondak was trying to accomplish by this letter.
But if you look in paragraph 16 of your September 26th decision, if you look in paragraph, on page 13, if you look on paragraph number 3 of the order, on page 14, I mean, and these are already things that they were supposed to have done already. I mean, that's what I don't understand. If they're using this in connection, if they're using these materials in connection with their landscaping business.
But they haven't said that. I don't think that's what they said.
What possible use why would they have bulk quantities of mulch, loam, fertilizer,
I
stone pavers?
I don't think that's there. I think Mr. Prondak said he saw one pile of,
Well, I also think I have an answer, and I think, again, part of the confusion, and Maggie Oldfield is right, this is an enforcement nightmare. However, what I think, their argument to me is, we're not doing landscaping, because you said when they sell, deliver, and install. I think what they're saying is, we sell and deliver their nursery, stop there. That's their argument.
But-
So where's that line? Where's my clear line?
I can draw it for you, right? They're talking about these materials are used in connection with their landscaping business. And paragraph 16 specifically says that they cannot store these materials on their property and use them in connection with their landscaping
why do you
business.
say it's in connection with the landscaping business? If I go to them and I say I want 30 cubic yards of mulch for my house, and they take it from the nursery site, they drop it off in my driveway, and they go away, and I have to spread it and use it to beautify my house. Why is that landscaping?
I don't know if that would be. I don't think.
I think that's what- I think that's what they're saying
I don't think
they're-
that's
they're
incidental
doing.
or accessory to a nursery, though. I mean,
Well,
it just-
that's
that's
that should-
incidental or accessory to a landscaping company.
Well, that's a question that we have to decide based on the evidence that we've seen here.
okay.
So it seems to me, in all candor, I want to read these materials, and I haven't had an opportunity to do it. Number two, I certainly don't mind taking a look at the site. We've done it before, we'll do it again. I don't think anyone's harmed by that. And then I think, Mr. Dunn, I don't want to impose on you or impose any undue expense on your clients either, but you haven't had a chance to read this material. I don't know whether you want to. Maybe you don't want to. You don't have to do anything. What I'm going to do is extend to you an opportunity, if you want, to respond or to reply to this prior to the next scheduled hearing. And when we go to that next scheduled hearing, from my view, unless my colleagues disagree with me, the evidence in this case is going to be over, and the board is going to deliberate and make a decision. We're not going to take any further evidence, but we will consider any written submissions that you want to make. And likewise, if Mr. DeLuna thinks he wants to submit something. The only caution that I'd want to have is that this be done reasonably quickly, and that any written materials, memoranda, affidavits, whatever it may be, that's going to be submitted, let's say, at least 1 week before the scheduled hearing, so that this won't happen again, and we'll have an opportunity to digest these materials, and everyone can assemble, and we'll make a decision one way or the other on these issues. And everyone can go off to see Paul Wilson in the Superior Court and see what he thinks of this. Okay, now,
Is evidence closing tonight?
yeah, I think it should, I think it should close, but
I
if,
think it should.
Okay, so Pam, do you want to talk?
sure. Okay, so that's gonna be a procedure, is that, and whether you wanna submit, you're not required
No, I
to submit
understand.
anything.
No, I understand.
You've made your point, we understand perfectly.
So is there gonna be, there's gonna be a site visit,
Yes,
and there's gonna be a follow-up hearing, which you guys are gonna deliberate?
yes,
Oh, okay, okay.
yes.
Just procedure.
If evidence closes tonight, how can further memoranda be submitted?
Well, memoranda on evidence.
Well,
It's legal arguments.
Exhibits to them would be.
Well, do you intend to be submitting additional?
I don't know. I have to, recoup with my clients and see what might be out there. I mean, obviously, my client has surprised me by taking one of the paragraphs off the list.
Oh, I thought he did that as an accommodation to try to end this particular aspect.
Yes,
of
I
it.
have not been able to have a chance to speak to them about that. They've done it, and that's fine and well, but I do need time to talk to my clients, and there may be other evidence. So I would request that the evidence remain open until the close of the hearing.
Okay, let me discuss that with my colleague.
That's fine with me.
Is that fine
That's
with you?
me. Can I make a suggestion to both of the lawyers? If your concern is really directed toward some waiver or estoppel argument that's gonna affect your Superior Court case, couldn't you guys deal with that by stipulation? That withdrawing this appeal will have no effect whatsoever on the Superior Court case?
I still have the issue then as to what can the nursery maintain on site? That would not address that issue. I'm about to go into a very busy,
But we've already, we've decided that you can't have a landscaping business, rightly or wrongly.
you've decided we can't have the landscaping business, but these are all components. This is 6% of the annual sales, it's a minimal amount.
Right, but what Brian, I think, is suggesting is that if you wanted to simplify this proceeding, that's an issue which you could be presenting to the Superior Court judge as part of a trial. I think Mr. Dunn is suggesting the same thing. As long as you protected yourself on the record that you have appealed from Mr. Prondak's enforcement order, and just you wail it out in front of the judge rather than having multiple hearings.
And that would be a year or two, there will probably be injunctions, my clients will lose a year to 2 years of being able to provide the public the sale of these goods that other nursery businesses can provide the public now. It's an economic disadvantage.
Okay. And so you want the board to decide this particular issue, knowing full well that if we decide it according to what we believe to be some type of an agreed-upon stipulation to some extent, so you've preserved your appellate rights, you're gonna be in the Superior Court, and you're gonna be faced with Mr. Dunn in his argument that the board had no legal jurisdiction to entertain this issue, and secondly, that somehow our decision should not be enforced. It should be restrained, and the judge is going to have to sort all of this out.
When I see how your decision is crafted, I can make that decision.
Okay, no, I understand what you're saying. Ginny, do you have any issues with respect to the evidence being continued to remain open for the next hearing?
As long as it's something that's, I don't want to see the same things again.
Right, and as long as it's
Narrow, keep it
short
narrow.
and sweet, and we're not going to get involved with hours of continued testimony, okay? And perhaps, if it's proffered maybe as an offer of proof in your written material, so we'll know what you're gonna present, so we won't have to hopefully listen to more evidence on these issues, okay? So with all of that having been said, that's what we're gonna do, but there's members of the public, at least 1 or 2 people, who do want to be heard. It's now 9:45, and we do want to hear from them, because they may not be able to be present next time. Why don't you come on up, ma'am, and have a seat by the microphone, tell us your name and address.
evening.
Hello.
My name's Pamela Farr. I live at 44 Forest Street. I'm the largest abutter to Thayer Nursery, and a couple of issues, and I will be brief. I
Could you
agree.
do me one favor? Could you spell your last name for us?
Lepore.
Thank you.
I, first of all, agree with Mr. Prondak that every nursery landscape company should be taken on its own merit. The other nurseries in town are all on four-lane highways. This is in a very thick, densely residential neighborhood, so I urge the board to please take that into consideration. The mulch basically is being moved from John and Phil's property to very close to my property. So they're just basically moving it from one abutter to another. So this is not going to end.
Could you tell me how far is the mulch from your residence? If
Well-
it's stored on the right-hand side of the barn?
Well, it depends on how far they come over. The recent plan that they've submitted puts it pretty close to my property. Right now,
Tell us in terms
right
of
now it's about
approximately
50
20
feet.
50 feet,
But
okay.
it's going to come closer. I know that for a fact. I'm hoping you can restrict the size of trucks that bring these loads in and restrict the amount of these materials being stored. Saturday, an 18-wheel truck was delivering the pile that's there now that I believe you saw this morning. It was noisy, the fumes, the beeping was very disruptive. The Bobcats were going all day Friday, moving things around. And this is the bulk of the problem here, the noise and our lives being disrupted. Unfortunately, Josh called the police on me because I was videotaping the 18-wheel truck and how long it idled and how it affected me and my life that day. I have a copy of that video. I'd be happy to supply you with the Bobcats on Friday and the 18-wheel truck on Saturday, if you'd like.
Do you have any photographs as opposed to the videos?
I can maybe frame some of them.
If you could, that would be
But
helpful.
it was awful. It was awful. The Bobcats were going all day Friday. It was my one day off, and that's why we're here before you over and over and over again. And this 18-wheel truck, it dumped a huge pile of loam. So if they're going to be taking this loam, picking it up from the Hillside Street site and taking it to their landscape jobs, that just doesn't make sense to me, how that could be allowed. So,
Thank you.
thank you.
Appreciate you coming. We appreciate you staying late. Is there anybody else who wants to be heard? Okay, the record indicates there's no such person. I thought I saw another hand back there, but no. Okay. So, Mary, we need a new date. What have you got for us?
April 28th, we have 3 cases. To May 14th, we have 4.
Want to go out that far?
There's nothing before the 28th.
Unless you guys have a free date. I don't have anything else scheduled. I don't know when you're available.
Can we just do a standalone?
I
Just
think
do
we
this
have to.
one night?
Don't you think?
Yes.
Maybe like
Okay.
April 16th or something like that, I don't know.
What do you mean, May 16th?
No, April.
April.
Yeah, don't we want to get this done?
We do. We do. How are you? What day of the week is that, you know?
16th is a Wednesday. Ooh, wait a minute.
No, I think that's probably too soon, don't you think, I don't know whether Mr. Dunn is gonna file written materials or not.
I'm just saying to give it to us so we can advance.
I know. So you wanna go out at least 2 weeks. What about the week of the,
21st?
yeah, week of the 21st? Now, the 21st, I think, is
a holiday.
is a holiday.
I'm gonna be
Yeah,
tied up that week.
We have a hearing on the week of the 28th. Which date do we have? The week of the 28th of April.
Yes.
Are we free?
Hold on, let me look at. Excuse me, it's April 24th, we have a hearing. Thursday, the 24th.
Okay, so we're free the week of the 28th? How about the 29th or the 30th, Tuesday or Wednesday?
It's fine.
I can
Jim?
do that.
Mr. DeLuna and Mr. Dunn, how about either April 29th or April 30th? That's Tuesday or Wednesday for the continued hearing.
Okay, Tuesday would be better because we're trying to do it because it's Thursday.
The 29th or the 30th?
One of the issues, and I don't mean to dance around the question, but one of the issues has to do with, there's a citizen's petition that has to do with amending the bylaws to allow there to continue operating the landscaping business that was prescribed. That's going before the planning board, and then it's gonna go before the warrant committee, so that's gonna require me to be at both those proceedings. So I can't be in two places at once, and I don't know when those hearings are gonna be held. I know that the planning board is going on the 23rd. It may be continued for a week, I don't know that. And I don't know when the warrant committee is gonna meet either. That's-
Well, I think what we should do is schedule it for either the 29th or the 30th, and if you need the continuance, just send us a letter, and we'll deal with it. You certainly should have the right to be appearing before the planning board and protecting the client's interests.
I'm sorry, what days of the week are those?
Tuesday, the 29th of April, or Wednesday, the 30th.
I have a matter on the 29th, but it's the better night for my client,
But
so.
he could do the
I
30th.
can, no, we'll do the 29th, and if Mr. Dunn can't do the 29th, then we'll reschedule to
The 29th is fine, subject to, is that okay?
Okay, so we're gonna do the 29th, and we're gonna be the only hearing on 7:30, presumably here.
Town election on the 29th, so this building's gonna be crazy.
So, no, that's not right, you can't conduct. a
Then we'll do it on the
public
30th.
hearing. Okay, the 30th. There's no town meeting. Wednesday. The town meeting is May, isn't it? Okay, so we're gonna do this, April 30th, 7:30, presumably here, that's a Wednesday. And any memoranda, affidavits, materials to be submitted to Mrs. Fitzgerald 1 week before then, so that'll be the 23rd. All right?
And are we gonna do
What about the site
a
inspection?
review?
Yes, and we're going to do a view at some point in time. Do you want to pick a time and date for the view? I think we probably should, because it's,
I can't do
if
it.
any member of the public wants to attend the view, they should know about it.
Tomorrow?
I could do a view tomorrow. Tomorrow's Wednesday, isn't it? Is it not?
Yes.
Okay. I could do tomorrow, or I could do Thursday. Presumably first thing in the morning, don't you think, so you won't lose the day? How are you, Mr. Dunn, either tomorrow or Thursday?
Thursday would probably work better for me.
Yeah, that's fine.
Mrs. King can't do Thursday.
You know, I could certainly go on my own.
She could go on her own, is that, she could do a self-inspection if that's... You available tomorrow morning, Joe? You don't have to be there, but if you wanted, you're certainly invited.
I could be.
Brian?
I could be there, like at 8 o'clock.
You're deadly. 8 o'clock in the morning. Can you make it, Ginny? Can you make it?
cannot make it.
You cannot, yeah, that, you've got a long way to travel,
I have some
perhaps.
personal stuff in the morning.
And Mr., that would be, it would be an imposition on Mr.
I
Delona.
would not make it, but I'm not going to the site visit.
Okay, all right, and either Maggie Oldfield or Josh would be present, and you want to have your associate there, or is that, you're going to waive
That's fine,
that too?
that's fine, I'll waive it.
Okay. Is 8 o'clock too early for you folks? You're probably up at 6 in the morning.
Tomorrow at 8 or Thursday?
No, how about your clients, Mr. Dunn, Mr. Joe Henning and Mr. Rowe? Are they able to make a view tomorrow morning? 8 o'clock?
Because you can't, no, Mr. Dunn can't be there at 8 o'clock tomorrow morning.
No, I know Mr. Dunn can't, but can you be there, or do you want to be there?
Yes, I want my attorney there. Is that unreasonable?
No?
Do you want to be there? Do you think you should be there?
Yeah, I mean, I'd like to be there if I can, I mean, it's,
All right.
Thursday would
What-
work,
what-
I just, in the morning I have,
Do you mean tomorrow morning you're busy
Tomorrow
on
morning I
business?
have personal
Okay, so Thursday is better for you.
Better? Well, how about tomorrow afternoon?
yeah, anytime, probably anytime after, say, 10:30 tomorrow. You know, Thursday is open.
Afternoon after, later afternoon is better.
Can you late afternoon?
Yeah, I'd rather do that. I don't want to do it in the middle of the day, that's for sure.
By late afternoon, we're talking
5 o'clock.
5 o'clock?
That works.
Does that work?
Yeah.
Mr.
Tomorrow.
Carter? Tomorrow. Okay, we're gonna do a view tomorrow, 5 o'clock. Everyone's invited, and we'll be at, meet outside of the front of the barn. Does that make it easier for you, Mr. DeLuna, or?
I am unable to make it tomorrow, period.
Okay, well, that's fine. Okay, so this hearing's continued until April 30th at 7:30. Written materials a week before then. We're gonna do a view tomorrow, 5 PM, public welcome. Meet in front of the barn. Probably 25 minutes, maybe half an hour, that's about it. Okay, thank you, we're gonna be adjourned for the evening. Thank you.
Thank you.